This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below. Hello everyone, I'm Leonard French, your favorite copyright attorney. Today I wanted to talk about attorney Hilary Clinton's recent suspension. Hilary Clinton is a well-known activist attorney and former U.S. prosecutor who represents conservative people and movements. He's known for repeatedly suing Hilary Clinton, and he tried to deport Barack Obama back to Kenya. He's even been barred from Judge William Keller's courtroom for life for his behavior in a 1992 D.C. district trial. More on that at the end of the video. In 1994, he founded the group Judicial Watch, a group that files Freedom of Information Act requests in order to investigate misconduct by government officials. He's also founded Freedom Watch, a group that is currently trying to sue China over the coronavirus. Hilary Clinton, who is already on administrative suspension in Pennsylvania for failing to keep up with his professional education requirements, has now been suspended again, this time for 90 days, this time by the D.C. Bar, and upheld by a 3-judge panel of the D.C. Court of Appeals. Let's read what happened. So here is the District Columbia Court of Appeals matter in re Hilary Clinton, a member of the bar of the D.C. Court of Appeals. So he is a member of the bar, and this is on the report and recommendation from the Board of Professional Responsibility, who makes reports and recommendations to the bar based on disciplinary complaints, either brought by outsiders, either the court or someone complains to the Board of Professional Responsibility, or they can sometimes bring things up on their own. And this is before a 3-judge panel: Judge Fisher, Judge Thompson, Judge Beckwith, all associate judges, apparently. The Board on Professional Responsibility has recommended that this court suspend respondent Hilary Clinton from the practice of law for 90 days based on his representation of 3 clients. So this is what the basis is: representation of 3 clients in violation of Rule 1.9 Conflict of Interest Rules of the District of Columbia Rules of Professional Conduct and the Florida equivalent. In this matter, the Office of Disciplinary Counsel takes exception to the board's report and recommendation on 3 grounds. First, disciplinary counsel challenges the board's rejection of the finding by Hearing Committee Number 9 that Mr. Klayman violated District of Columbia Rule of Professional Conduct 8.4d, which we'll go over in a moment. Second, disciplinary counsel takes exception to the board's rejection of the Hearing Committee's finding that Mr. Klayman gave false testimony and made false representations to the Hearing Committee. Finally, disciplinary counsel takes exception to the board's recommendation that we impose a 90-day suspension without a requirement that Mr. Klayman prove his fitness before being reinstated. For the reasons that follow, we accept the board's recommendations. Mr. Klayman founded Judicial Watch and served as its in-house counsel from its inception in 1994 until 2003. During Mr. Klayman's tenure at Judicial Watch, Sandra Kobus served as the director of Judicial Watch's Miami regional office. She complained to Judicial Watch about her employment conditions, alleging that she was subject to a hostile work environment during several weeks in 2003. As general counsel, Mr. Klayman provided legal advice to Judicial Watch concerning Kobus's claims. After both Mr. Klayman and Ms. Kobus had ended their employment with Judicial Watch, Ms. Kobus filed a complaint against Judicial Watch in Florida State Court, making the same hostile work environment allegations. The Florida trial court granted a motion to dismiss the case, calling the complaint silly and vindictive. Thereafter, without seeking consent from Judicial Watch regarding the conflict of interest, Mr. Klayman entered an appearance on Ms. Kobus's behalf and filed a motion requesting that the trial court vacate its order of dismissal. When the motion was denied, Mr. Klayman filed a notice of appeal on Ms. Kobus's behalf and later a brief in a Florida appeal court, but the appellate court affirmed the dismissal. In 2002, while still employed by Judicial Watch, Mr. Klayman solicited a donation from Louise Benson as part of a campaign to raise funds to purchase a building for the organization. Mr. Klayman was acting as both chairman and general counsel of Judicial Watch when he solicited this donation from Benson. Ms. Benson committed to donate $50,000 to the building fund and thereafter paid $15,000 towards the pledge. Judicial Watch did not purchase a building. In 2006, after Mr. Klayman had left Judicial Watch, he and Ms. Benson filed a lawsuit against Judicial Watch in federal court, where they were represented by attorney Daniel Dugan. Ultimately, the federal district court dismissed Ms. Benson's claims, but not Mr. Klayman's, on jurisdictional grounds. Shortly thereafter, Ms. Benson sued Judicial Watch in the Superior Court of the District of Columbia, alleging, among other things, unjust enrichment and seeking a return of her donation. Initially, she was represented in that suit by Mr. Dugan. Eventually, and without seeking consent from Judicial Watch, again, conflict of interest, Mr. Klayman entered an appearance in the case as co-counsel for Ms. Benson. Judicial Watch requested that Mr. Klayman withdraw, stating that he organized the fundraising effort that was at the center of Ms. Benson's complaint while he was Judicial Watch's attorney, and noting that Ms. Benson had identified him as a fact witness. When Mr. Klayman did not withdraw, Judicial Watch moved to disqualify him. The motion for disqualification was never decided, as the parties stipulated to the dismissal of the case, so potentially some kind of settlement. In 2001, while Mr. Klayman was still employed by Judicial Watch and Peter Paul entered into a representation agreement and a modification thereto, under which Judicial Watch agreed to evaluate legal issues emanating from Mr. Paul's fundraising activities during the election campaign for the New York State Senate in 2000. And to represent him in connection with an investigation into alleged criminal securities law violations and possible civil litigation stemming from those fundraising activities. Mr. Klayman drafted, edited, and approved the representation agreement and modification and authorized the signing of both documents as Judicial Watch's chairman and general counsel. Judicial Watch later represented Mr. Paul in a civil lawsuit brought in California State Court. Following Mr. Klayman's departure from Judicial Watch withdrew from the representation. Thereafter, Mr. Paul sued Judicial Watch in the United States District Court for the District of Columbia, alleging, among other theories, that Judicial Watch breached its representation agreement with him. While Mr. Paul initially was represented by Mr. Dugan, Mr. Klayman entered an appearance in the case without seeking Judicial Watch's consent, again, conflict of interest. Judicial Watch moved to disqualify Mr. Klayman. The district court, the Honorable Royce C. Lamberth, granted the motion to disqualify, finding that Mr. Klayman's representation of Mr. Paul violated Rule 1.9 of the Rules of Professional Conduct. The court found that Mr. Klayman was representing the plaintiff in a matter directly arising from an agreement he signed in his capacity as general counsel for the current defendant. So can't represent the plaintiff and the defendant in the same matter. And that Mr. Klayman's representation of Mr. Paul was the very type of changing of sides in the matter forbidden by Rule 1.9. The hearing committee found that Mr. Klayman violated Rule 1.9, or its Florida equivalent, in all three matters, and violated Rule 8.4d in the Paul matter. It also found that Mr. Klayman gave false testimony before the hearing committee, and that his disciplinary history in Florida in connection with an unrelated matter was another aggravating factor. On the basis of all of the foregoing, the hearing committee recommended that Mr. Klayman be suspended for 90 days, with reinstatement contingent upon showing of his fitness to practice law. The board, by contrast, recommended that Mr. Klayman be suspended for 90 days with no fitness showing requirement. The board disagreed with the hearing committee's finding that disciplinary counsel proved a violation of Rule 8.4d, and with its finding that Mr. Klayman provided false testimony. Before this court, neither Mr. Klayman nor disciplinary counsel takes issue with the finding that Mr. Klayman violated Rule 1.9 or its Florida equivalent in the matters described above, and we therefore need not address that finding. Rather, as the board did, we adopt the vast majority of the hearing committee's thorough analysis. However, as noted above, disciplinary counsel takes exception to the board's findings regarding Rule 8.4d and false testimony to the board's recommended sanction insofar as it omits a fitness requirement we will discuss now. Disciplinary counsel has the burden of proving a violation of the rules of professional conduct by clear and convincing evidence. So that's our standard of review, is clear and convincing evidence. When reviewing a recommended disciplinary sanction against an attorney, this court must accept the board's findings of fact as if they are supported by substantial evidence. The board has the power to make its own factual findings, but must accept the hearing committee's evidentiary findings, including credibility findings, if they are supported by substantial evidence. Substantial evidence means enough evidence for a reasonable mind to find sufficient to support the conclusion reached. The board and this court owe no deference to the hearing committee's determination of ultimate facts, which are really conclusions of law and are thus reviewed de novo, or brand new. Whether a respondent gave sanctionable false testimony before the hearing committee is a question of ultimate legal fact that the board and this court review brand new or de novo. This court usually adopts the board's recommended sanction unless to do so would foster a tendency towards inconsistent dispositions for comparable conduct or would otherwise be unwarranted. Rule 8.4d establishes that it is professional misconduct for a lawyer to engage in conduct that seriously interferes with the administration of justice. For conduct to violate Rule 8.4d, the conduct must be improper, bear directly upon the judicial process, and taint the judicial process in more than a de minimis or minimal way. Disciplinary counsel asserts that the board erred by overturning the hearing committee's conclusion that Mr. Klayman violated Rule 8.4d when he appeared on behalf of Mr. Paul with a clear conflict of interest and litigated against disqualification for the second time. The board cited a number of reasons for rejecting the hearing committee's conclusion, including its long-standing concern about the scope of Rule 8.4d in litigation-related disciplinary matters, and its view that any Rule 8.4d violation would be derivative of the conflict of interest finding. In other words, the conflict of interest and Rule 8.4d would end up punishing the exact same conduct twice, when it's really the primary misconduct was a conflict of interest violation. But the board primarily followed this court's lead in considering the views of the judge who presided over the litigation in which the disqualification motion was filed. The board found it extra significant that Judge Lamberth, though he granted the motion to disqualify Mr. Klayman, found a legitimate debate about Mr. Klayman's conduct, and further found that Mr. Paul was a needy client who could not otherwise have afforded legal services. In light of the extraordinary situation of Judge Lamberth's supportive testimony to the hearing committee, the board was unable to conclude that Mr. Klayman's behavior sufficiently tainted the judicial process to a degree adequate to sustain the Rule 8.4d charge. The board noted that in White, by contrast, Judge Lamberth concluded that White's conduct had tainted the proceedings. Specifically, the entire litigation was disrupted and delayed while the district court dealt with the motion to disqualify, and the court had to strike an entire deposition because of White's presence. So, different. We accept the board's reasoning regarding Larry Klayman and agree that no Rule 8.4 violation was provided by clear and convincing evidence. Before the hearing committee, Larry Klayman testified, "I believe that Mr. Dugan had given the advice of counsel that I could do this, i.e. represent Ms. Benson, otherwise he, Dugan, wouldn't have prepared the pleading, opposing the motion to disqualify Mr. Klayman based on Rule 1.9. The hearing committee found that this testimony was false, as was Mr. Klayman's testimony that Mr. Dugan was the one who prepared the response to that disqualification motion. Disciplinary counsel contends that this court should defer to the hearing committee's false testimony findings as supported by substantial record evidence. The board found that disciplinary counsel failed to prove by clear and convincing evidence that Mr. Klayman gave false testimony. The board observed that the hearing committee had relied almost entirely on Mr. Dugan's testimony that he did not endorse Mr. Klayman's appearance in the Benson matter. The board reasoned, however, that the forcefulness of Mr. Dugan's testimony was undercut by his repeated inability to recall the substance of key conversations that took place between him and Mr. Klayman 8 years earlier. In addition, the board cited prior apparently inconsistent statements that Mr. Dugan had made about the matter, e.g., Mr. Dugan's apparent statement to Judicial Watch's counsel referred to in Judicial Watch's memorandum in support of his motion to disqualify, that there was no ethical issue arising from Mr. Klayman's representation of Ms. Benson. The board's description of Mr. Dugan's diminished recollection of his discussions with Mr. Klayman about the latter's entry of his appearance in the Benson matter, and about Judicial Watch's demand that Mr. Klayman withdraw from the representation is supported by the record. Further, while the hearing committee reasoned that Mr. Klayman cannot have inferred that Mr. Dugan blessed his entry of appearance in the Benson matter from Mr. Dugan's filing of the opposition to the motion to disqualify, since Mr. Dugan did not write the opposition, Mr. Dugan acknowledged that his associate may have edited the draft opposition before it was filed, acknowledged that he, Dugan, did sign the opposition, and testified that he would not have done so if he thought that it was frivolous or that it violated any ethics or pleadings rules. Additionally, Mr. Klayman's testimony was to the effect that the circumstances caused him to believe Mr. Dugan had given the advice of counsel. We agree with the board that there was not proof by clear and convincing evidence that Mr. Klayman testified dishonestly as to his belief and recollection. Accordingly, we accept the board's conclusion, rejecting the finding that Mr. Klayman testified falsely. In explaining its sanction recommendation, the hearing committee found that Mr. Klayman's misconduct was aggravated by his prior discipline in Florida and his denial of responsibility as to the underlying conduct. He received a public reprimand in that jurisdiction after he failed to timely pay the full amount of $5,000 he had agreed to repay to a former client after mediation to resolve a fee dispute. The board gave this matter little weight because Mr. Klayman's explanation that a serious car accident had rendered him unable to work at full capacity and caused him significant financial difficulties that affected his ability to pay. We accept that evaluation. We also accept the board's conclusion that disciplinary counsel did not show that a fitness requirement is warranted in this case. To be sure, disciplinary counsel proved that Mr. Klayman flagrantly violated Rule 1.9 on 3 occasions. His misconduct was not isolated, and it appears he acted vindictively and motivated by animus towards Judicial Watch, with which he had developed an acrimonious relationship. We agree with the board and the hearing committee that his misconduct was intentional rather than inadvertent or innocent. We also readily agree with the board that his misconduct, involving a switching of sides that strikes at the integrity of the legal profession, deserves the serious sanction of a 90-day suspension. Nevertheless, we are not left with serious doubt or real skepticism that Mr. Klayman can practice ethically. Accordingly, we decline to impose a fitness requirement. We do, however, concur with the disciplinary counsel's original recommendation that Mr. Klayman be ordered to complete a continuing legal education course on conflicts of interest. Wherefore, effective 30 days after entry of this order, Mr. Klayman is suspended from the practice of law. The period of suspension is 90 days, commencing after he has filed the affidavit required by the DC Bar. Before reinstatement, he must also complete a CLE course on conflicts of interest, so ordered. The pending motion by his counsel to withdraw is hereby granted. So wow, that's really interesting. Larry Klayman apparently tried to represent, or sort of partially represented, clients who had claims against his former client, and that's a conflict of interest. We have something here called Rule 1.9 of the Model Rules of Professional Conduct. Some version of the model rules will be adopted by the various states. And it says right here, the first one, a lawyer who has professionally represented a client in a matter shall not thereafter represent another person in the same or substantially related matter in which that person's interests are materially adverse, or conflict of interest, to the interests of the former client, unless there is informed consent confirmed in writing. So it seems like Larry Klayman violated that rule. Now, I said that we'd go over how he got kicked out of one judge's courtroom. Let's take a look at that then, and then we'll look at yet another ethics complaint against him that might have even worse consequences. So here is Baldwin Hardware Corporation v. Klayman and Associates, and this is in the U.S. Court of Appeals. This is March 4th, 1996. So this is a little while ago. We're not going to go over the whole thing. I'm just going to read like the first page. This regrettable appeal has its origins in design patent and trademark infringement litigation brought by Baldwin, an American manufacturer of bathroom and door hardware, against Frank Su Enterprise Corporation, a Taiwanese competitor, along with Mr. Frank Su's owner, and Decorators Accessories Limited, a Frank Su distributor. Judge William D. Keller of the Central District of California presided over a 7-week trial and the motions practice preceding trial. Pre-trial proceedings, particularly discovery proceedings, in this matter were marked by appellants' delays in complying or failure to comply with the court's rules and orders. On December 9, 1991, Judge Keller assessed against K&A attorney's fees and costs incurred by Baldwin in responding to appellant's ex parte application for an extension of time to oppose Baldwin's summary judgment motion and for a continuance of the hearing date of the motion. Judge Keller found that K&A filed its application for an extension 3 days after the opposition due date, and that the only proffered reasons for lateness, extensive business travel, and the errors of an associate at the firm, were insufficient. Early in the trial, conducted in 1992, a reference was made to Baldwin's parent company, Masco. The next day, Judge Keller informed the parties that at the time Baldwin filed its complaint in September 1990, the judge's mother had owned shares in Masco as part of a trust fund naming Judge Keller as the beneficiary. The trust sold the shares in November 1990 before the judge had become involved in any way in the case. Because the shares had been sold well before Judge Keller became involved in the case or knew that Masco was related to one of the parties before him, and given the amount of time he had spent on the case to date, the judge concluded that he was not required to recuse himself. Both parties expressly agreed with this conclusion. During the course of the trial, however, appellants requested that Judge Keller recuse himself under the law. Appellants cited the following grounds: 1, that Judge Keller had prejudged the case, and 2, that Judge Keller had, at some point in the case, a prospective financial interest in Baldwin's parent company, Masco. Judge Keller denied the motion after addressing each of the instances of alleged prejudgment raised by appellants. He also addressed the Masco issue for a second time and concluded that the circumstances did not warrant recusal. Over the course of the trial, Judge Keller admonished Mr. Klayman several times concerning his conduct of the proceedings. For example, failing to provide advanced written notice of the prior art appellants intended to use during trial as required by the law. Failing to have Mr. Frank Sue appear in court on the appointed day after the trial court had granted an extension of time to allow Mr. Sue's travel from Taiwan and preparation by counsel, and lodging a late request for a jury trial on the patent issues in the case after admittedly waiving a jury trial for such issues at a pretrial status conference. Additionally, Judge Keller expressed increasing frustration with Mr. Klayman's practice of continuing to speak after the trial judge requested silence. Following the close of trial, Judge Keller, sua sponte, or on his own, ordered Mr. Klayman permanently and prospectively barred from appearing before Judge Keller pro hoc vice in any future litigation. Judge Keller cited several actions by Mr. Klayman during the trial as grounds for the order. Additionally, Judge Keller sanctioned K&A under the law for unreasonably and vexatiously multiplying the proceedings and awarded Baldwin attorney's fees and expenses incurred with respect to various aspects of the trial. Judge Keller incorporated the sanctions order into his final judgment in the case. Wow, so attorney Klayman didn't conduct himself properly in the case and got literally thrown out of the judge's courtroom, like, never appear before me again on your own. You must do it with co-counsel who you then pro hoc vice in through or something. Pro hoc vice is getting admitted when you're not admitted to that court. Like, my cousin Vinny had to go and try to convince that Alabama judge that his New York attorney style would translate down to Alabama and he'd be able to adapt and adopt the court's law down there, the state law and the court's procedures. And of course, the movie was fun because he didn't really adapt and adopt their procedures and laws. But, oh, and he lied to the judge. Don't lie to the judge. That was a bad idea. That would be worse than this. If the judges and bar and everything here had found Klayman had lied to them, this would be even worse than this. So that didn't happen. But now there is something else here to show you. Apparently another ethics panel, or maybe even a same ethics panel in a different matter, is now issuing a 183-page report saying that Klayman breached his professional ethics, making romantic advances towards a woman he represented. So not these allegations, something else. They're recommending something along the lines of a 33-month suspension, which I guess I'm not even sure if I've heard anything when you start to get up to like 3 years, that's where you start to get at. The line now is to permanent suspension. You don't get suspended for 5 years or 10 years or something very often. You get suspended for 3, and I think most of the time after that, you get suspended permanently. So who knows what's going to happen with this one. But yeah, so he faces several egregious violations of the rules of professional responsibility here. Let me maybe zoom in a little bit. Scope of representation, communications with a client, confidentiality, and conflicts of interest. He says it's a political hit job. And he says other claims like this were filed in Florida and Pennsylvania, and those claims were dismissed around 2010. So that might be part of a fishing expedition, but if he's got to the point that he or the ethics panel recommends a 33-month suspension, there's enough evidence there for them to recommend that. And just a little more background, he is the person who represented Arizona Sheriff Joe Arpaio and the activist rancher Klayman Bundy. There was an armed standoff there with Klayman Bundy, and so he's a bit of a controversial figure. But here on Lawful Masses, we don't really judge the attorneys by who they choose to represent. Everyone deserves justice, whether it's a person who is saintly or a person who is not. And they deserve their due process, they deserve their rule of law, they deserve their equal protection, because that's how it works for all of us. And that's also the basis on which we can say that other people should not be above the law either. Police should not be able to skirt the rule of law and avoid prosecution for crimes either, just like any civilian should. So the law works equally for all people. So I don't judge Larry Klayman for representing people who I disagree with those people. I do disagree with Larry Klayman not being a proper ambassador to the profession, not following his rules of professional conduct and conflict of interest. Skirting these rules sort of gives people or other attorneys or those who are skirting them a little bit of a cheater's advantage. And so they get to get a little bit ahead. If they don't get caught, then they've successfully cheated their way ahead of other people. So it's also not really becoming of an attorney who's supposed to be representing you in an honest way as an officer of the court, instead of using illegal advantages, a conflict of interest, having confidential information and being able to use it against your opponent because you represented your opponent as well. So that's not fair. That's just not a fair fight. And remember, we're not in an unfair fight situation. This isn't the battlefield. This isn't war. This isn't all no holds barred, every man for himself kind of thing. This is our civilization's chosen mechanism to resolve its disputes in a civilized way, in a non-violent way. This is our preferred way to resolve disputes. So we want to encourage people to use the court system. We want to encourage people to hire competent and honest and decent attorneys to represent them and adjudicate their matters fairly, so that the actual truth can result in effective justice. Let me know what you think in the comments below. And that's our show. Thank you for joining me. I'm Leonard French, your favorite copyright attorney, and this is Lawful Masses, your favorite legal news and education channel. This channel is community supported, meaning your financial support on a monthly basis keeps us going and making videos. Thank you in the month of June to the following $50 plus supporters: Joe Tyson, Wes Delj, Citizen of the Sovereign, John Steele, Gavin Barnard, Eevi, Kyle Mudrak, Spirit Bear, Jan Negrey, Michael Pearce, Daniel Perez, Blackleaf, Benjamin Hitov, Stephen, Ottah, Cute Grills in Your Area, Longreach Jones, Definitely Not Prenda Law, Ugly Grill, Shielo T, Josh Baker, Gregory, Rudolph Bescherer Jr., Kristian, Hellman, Jay Dixon, Ameknight, Oscar the Phrophet, and Hot Grills in Your Area. And the $5 plus supporters are scrolling on the LED panel and in the description of the videos that drop and on the crawl in front of me now. I love you all. I'll see you in the videos. Have a good one. Here's some dog video. Bye. Chance to rub my nose. This thing itches everything. Everything it touches itches. Rah. I think there's even one in my eye. A little hair, a little plastic. Yep, a little plastic hair in my eye.